Hello, my name is Benjamin Hart. I'm an American attorney and managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing, this is kind of an alert. I'm not making this to be sort of overly hyperbolic, but when changes kind of are on the horizon like this, especially in a U.S. immigration context, I like to kind of get out ahead of it. And I thought of making this video after watching another video, actually. It's by Jim Hacking over at his channel, which concentrates pretty heavily on U.S. immigration. In fact, I think it's the exclusive bailiwick is U.S. immigration. We're a little bit more generalist over here, and then obviously we're kind of a unique channel insofar as we pretty well talk about Thailand. Although, as folks who've watched this channel with any regularity will know, we do talk about U.S. immigration. I've done U.S. immigration from here in Thailand primarily for going on a decade and a half now at this point. So. I'll go ahead and put a link to the video in the description so folks can go over there directly and see Mr. Hacking's analysis. Quite good, frankly. The minute I saw it, I was like, I got to make a video on this. And he brought up a good point. Now, I believe the case he was talking about, it was originating out of Nigeria. And for those who think that there's, oh, well, one part of the world is different. Yeah, it might be for the moment, as he gets into and talks about in his own video, but it doesn't necessarily mean it won't stay mutually exclusive forever. That's been my experience. So what exactly are we talking about here? As he brings up in his video, and frankly, I would urge those who are watching this one that really want to get into this, go check out his video as well, because his analysis is more in-depth, and he was actually dealing with one of his own cases where he saw this pop up. But the minute I saw it, I've seen how this has played out over 15 years, and this could be pretty game-changing if this is a trend that is coming to the forefront. So what's going on? Well, just to paraphrase him, basically he had a case. It was a case involving a couple. They had tried to obtain a visitor visa, I think before they even got married, and then the visitor visa was denied. As we've discussed in many, many videos on this channel, Section 214B of the Immigration Nationality Act results in a number of denials of U.S. tourist visas, especially in cases where there's any kind of thought in the consular officer's mind that there may be a romantic relationship with an American, because they're worried that person's going to use a tourist visa to circumvent the immigration process, go to America, essentially marry their spouse, and then file for permanent residence from the United States, which consular officers don't want to see that happen, so that's why they kind of guard against this. And Section 214B and the doctrine of consular non-reviewability, which we've discussed in other videos, all of those kind of play into that, how they actually adjudicate those findings. But long story short, as we've discussed in other videos, the visitor visa was denied, and then I think, if I remember correctly, the couple then got married, or maybe they were already married, I can't remember what it was, but in any event, they turned around, filed an I-130. They filed for immigrant spousal visa benefits thereafter. Now, this is where the rubber meets the road, and this is where, when I saw his video, I was like, wow, if that is coming online, that could have a tremendous impact. And I suspect if it's going to have an impact, it could have an impact out here in Southeast Asia. It might not be today or tomorrow, but it could. And one of the big reasons I want to be clear on this as to why I think it could, well, let me get into that in a minute. But long story short, this is where the rubber met the road. They had filed for a visitor visa, then they turned around and filed for an I-130. As we've discussed in other videos involving fiancé visas, as well as marriage visas, generally speaking, that initial visitor visa, as long as you tell the truth in the application, the denial is not going to be that big of a deal. I hate to use a colloquialism there, but I have never seen a prior denial in the past. It can weigh on things. I generally want to see a copy of the filing associated with a prior visitor visa, but in my experience, it was denied, no harm, no foul. You just sort of lose your application fee. But as he brought up in his video, a situation arose in the I-130 process where a request for evidence was issued, and in the RFE, it became clear that Department of State was talking to USCIS about this prior denial of this tourist visa. of this visitor visa. Now, if that is happening, that is substantial. That is a big deal, because this could change the way, in my opinion, cases should be analyzed from the get-go. So, for example, here in Thailand, in the past, people have contacted me before or after filing for a visitor visa, and generally speaking, filing for a visitor visa, the denial does not have any lasting ramifications. And let me be clear, the denial itself doesn't necessarily have any lasting ramifications. It's the application occurring at all which may have ramifications on a subsequent, in this case, an I-130. That's what he was talking about here. And I can't stress this enough. This has not been the case up to now. Okay, I've never heard of Department of State talking to USCIS about a filed case, a previously denied tourist visa in the context of the adjudication of a filed I-130. I have not heard of that, unless we're talking about an issue of fraud and misrepresentation, but I've only ever even heard of that in the context of an issued tourist visa, not anything associated with a denied tourist visa. And I'm not going to get too into the analysis on the difference in that. But long story short, when I heard this from him, that he was seeing this issue, my ears perked up. Next thing to think of is, as he said, now there may be those who say, well, the case involved, it came up in Nigeria. I'm not sure if Nigeria is considered what's called a high fraud post, but let's presume for the purposes of this video it is. And there may be those who say, well, that may be a new high fraud post, protocol that they're just doing now or something. Well, as we discussed, if we go back into this channel's history, when we were discussing the so-called Muslim ban under the Trump administration, there were many who took the position that, oh, that's not a big deal. That's only going to affect the countries that the ban specifically speaks to. Nothing to really see here, nothing to really worry about here. Why get all worried about it? And my response to that at the time was, no, actually it was an overarching policy change, as we discussed in detail at the time. It had different ramifications in different places. As he noted in his video, oftentimes when the folks inside of these agencies and bureaucracies find a tactic or a protocol, or they create one and they like it, they tend to keep using it. And that was kind of the thinking at the time in the analysis of the extra sort of adjudicatory scrutiny that went into the quote-unquote Muslim ban guidelines, where we saw ramifications of that at a local level here in Southeast Asia. It didn't have anything to do with Muslims or anything to do with like a terrorism context or whatever they were talking about in different places, but they created a new framework where they said, are there essentially hot button issues in your region which we should be concerned about in a given case? And it resulted in a kind of a broad application of the underlying scrutiny that was applied per the administrative rules that were created in that Muslim ban framework. The minute I heard about this with respect to prior visitor visas, especially denied visitor visas, again, my ears perked up, and it caused me to immediately start saying, well, does that mean there's going to be ramifications in the context of U.S. marriage visas? For example, the CR1 or IR1, the K3, even the K1 Fiancé visa. If there's a situation where they've applied for and been denied a tourist visa in the past, is that going to make those cases harder to process, longer to process? The question is out there. I don't exactly know the answer to that, but it is something that those who are looking to bring a loved one to the United States should seriously be considering. Because I understand, like a lot of people, especially folks that we deal with who get initially denied, they usually come to us after being denied on a tourist visa application, and usually they're not real happy about it because they didn't really understand that it's pretty hard to get one of those visas, especially here in Thailand, especially under Section 214B. But for the most part, in my experience, it hasn't really had any impact really much at all on a subsequent K1 visa case or a subsequent U.S. marriage visa case. It needs to be disclosed sometimes, depending on circumstances in the case. But That's basically it. You just basically say, yeah, we applied for that before, we were denied on it, now we're seeking this. And there wasn't a big issue with that. If that is changing, this could be major for those who are looking to bring a loved one back to the United States, because if you haven't applied for a tourist visa, you may need to contact somebody to do the analysis on whether it's even a good idea to do that, or to just immediately go for example, a marriage visa, fiancé visa, without even trying for a tourist visa. And I'm not saying that's necessarily the case. It's going to be fact-driven. It's going to be driven by the underlying circumstances of your case. But it is something to consider. And the moment somebody like him, in my opinion, somebody I really respect, especially a guy on YouTube, he gets a lot of good information on U.S. immigration out there. The moment he mentioned that, I said to myself, wow, that is something that could have tremendous long-term ramifications if that gets more broadly applied to a lot of different cases around the world in the future.